Dear comrades and friends, I welcome all of you to join this educative series of AIPRPA. Today I will discuss about commutation of pension. I have taken this issue because it is one of the important items that is governing the minds of all the pensioners. We are still demanding that the period of restoration of commutation of pension should be further reduced from 15 years at present. Therefore, I have decided to take up this issue today. For the benefit of all readers, I have decided to bifurcate the issue into 12 parts. The first part is the rule governing the commutation of pension. What is the rule that governs the payment of commutation of pension to all civilian pensioners? It is called Central Civil Services Commutation of Pension Rules 1981. It has become effective from 1st July of 1981. Secondly, I will take up the issue of applicability. Who are all eligible to receive the commutation of pension? Number 1, Chapter 5 of the CCS Pension Rules 1972 narrates 7 types of pensioners. All the pensioners who are coming under Chapter 5 of CCS Pension Rules 1972 are eligible to draw the commutation of pension under the CCS Commutation of Pension Rules 1981. Who are they? They are superannuated pensioners, retiring pensioners, invalid pensioners, compensation pensioners, compulsorily retired pensioners, compassionate allowance drawing persons, and absorbees in public sector units and autonomous bodies. These 7 sections who are covered under Chapter 5, which is called the classes of pension and conditions governing their grant. This is the Chapter 5 of CCS Pension Rules 1972. All of them are made eligible to receive commutation of pension. Then come, who are the sections who are not entitled to receive commutation of pension? Number 1, all the NPS pensioners are not made eligible. Those who were recruited on or after 1/1/2004 and brought under National Pension System or New Pension System, they are not eligible to draw the commutation of pension according to these rules. And secondly, there are employees and pensioners who are proceeded under disciplinary rules on the eve of their retirement and then converted into Rule 9, and the enquiry is continuing. Those whose enquiry under Rule 9 are continuing, they are not eligible unless and until the enquiry is completed and they are given pension in full or in part. They are not eligible to draw any commutation of pension if Rule 9 proceedings are still in work. This is called the non-applicable areas of the pensioners. And then we will come to the question of eligibility without medical examination and eligibility after medical examination. There are 2 types of pensioners for whom medical examination is a must before drawing commutation of pension. There are pensioners for whom without any medical examination commutation of pension can be distributed. First we will take up the eligibility without medical examination. All the superannuated pensioners are eligible to draw pension without any medical examination. Similarly, the retiring pensioners are also eligible to receive commuted pension. And then the absorbees in public sector units, autonomous bodies, they are also eligible to receive the commutation of pension. Those pensioners who are given compensation pension are also eligible to draw commutation of pension according to rules. according to rules. Pension in full or part granted after the completion of Rule 9 departmental inquiry or judicial proceedings within 1 year, they are also eligible to draw commutation of pension without any medical examination. So these are the 5 areas where commutation of pension is allowed without any medical examination. Now let us move over to that area where medical examination is compulsory for drawal of commutation of pension. Number 1, invalid pensioners. People who are going on invalidation, they must undergo a medical examination to claim this commutation of pension. And all compulsorily retired pensioners must undergo a medical examination in order to claim the commutation of pension. Similarly, compassion allowance drawing persons are also to appear before the medical board and produce a medical certificate given by them to claim the commutation of pension. The pensioners who are retired and drawing pension as per Rule 12 of the rules, they are eligible. Similarly, the superannuated pensioners are also eligible after Rule 9. Rule 9 proceedings are over and they are given full or part of pension are also eligible, but they should undergo the medical checkup. Medical certificate is a must if they are applying for commutation of pension after the lapse of 1 year. Similarly, any application that is received by the accounts officer after the lapse of 1 year, again they have to give another application and undergo medical test in order to claim this particular commutation of pension. There are 4 types of forms available for commutation of pension. One is Form 5. Form 5 is used along with the other retirement superannuated pension forms by the employees before retirement. And those who have failed to claim or those who want to make additional claim before retirement, they can give Form 1A after the submission of their pension papers and Form 5 to the department. They can give Form 1A in order to claim the commutation of pension. Form 1 is used by the pensioners who do not make any claim at the time of the retirement, but they want to claim the commutation of pension. They can claim by using the Form 1, but within 1 year of their retirement, they should apply. If their application is received late, then they have to give Form 2. Similarly, all pensioners who want to avail the commutation of pension after the 1 year of their retirement, they have to apply in Form 2 and undergo a medical examination also in order to claim the commutation of pension. This is the forms that are used for commutation. What was the position of commutation of pension earlier to the present rules? Earlier, the commutation of pension was given maximum of 1/3 of the pension only. After giving 1/3 of the pension commuted, the pensioners have to receive the reduced pension for their lifetime. There was no maximum time fixed for restoration of the commuted pension. Instead, for the lifetime of the pensioner, the pensioner lives for more than 25 years after retirement, and all the 25 years, the pensioner has to get the reduced pension only once he receives the commuted value of the pension. But there was a court case. A court case was filed in the year 1986. And you know who was the petitioner in that court case? The petitioner was called the Common Cause. Common Cause is a very famous NGO functioning from Delhi. They have involved in this case and challenged the rules of CCS Commutation Rules 1981 of certain provisions of the rules 1981 and said that without any restoration period, it cannot be recovered from the lifetime of the pensioner. So they have raised so many questions, and the government tried to answer, but it could not challenge the basic aspect of the case in which the common cause has raised, that the life expectancy of the pensioners has increased. Once life expectancy has increased, so naturally there must be a limit for recovery of the amount. It cannot be a lifetime affair. This was the basic argument of that NGO common cause. The government could not answer. The court accepted that argument and tried to convince the government that the government should frame rules in order to pay back the commuted value, and therefore it gave time to the government, and government also taking considerable time. It has presented a paper to the court in which 4 points it has raised. It has accepted that from 1486 as a cut-off date, we will say the commuted portion will be restored. Number one. Number two, this will be applicable only to civilian pensioners and not to army personnel, because army personnel retire earlier and they are given 43 to 45% of commutation value, unlike the civilian pensioners who are granted only one-third of the pension for commutation. So we cannot give to army pensioners, we can give to only civilian pensioners. This is number two. Number three, we will restore it after 15 years. This is what they have said in their paper, and also they said, out of goodwill the government is doing this, therefore we expect that the pensioners will not raise this question again and fight their demand. And these are the 4 issues the government has presented in a paper to the court. But the common cause did not agree for 15 years. It said 15 years is too longer a time for repayment of the total commuted value. It said 12 years is enough. So after 12 years it should be given back. The court finally said, we cannot reduce the 15 years because many state governments have by this time restored the commutation of value in 15 years. Therefore, we cannot reduce that 15 years time today. So the court has taken 15 years will be the time of restoration of the commuted value of pension. But it did not agree with the government on this point, namely, it will be applied only to civilian pensioners and not to the army pensioners. The court said the army pensioners are given the concession because of certain factors, and that cannot be a reason for denying the restoration of commutation of pension. So it should be applicable to both civilian pensioners and also to army pensioners. And it did not agree with the cut-off date. It said 1486 is not correct. It should be 1485. Therefore 1485, 15 years, and it should be applied to both civilian pensioners and also to army pensioners. This was the final verdict of the Supreme Court, and the judge of that case was Jagannath Mishra, headed bench, 2-member bench headed by Jagannath Mishra. The petitioner was common cause, and we should understand this common cause has taken up very many important issues in our country and also for pensioners. Even the 17/12/1982 judgment, which Nagara judgment we famously call it, that Nagara judgment also, because common cause was a party in the case and all the expenditure was borne by the common cause, which the government also opposed in the petition, that the common cause has no business to be in the case, but the court did not agree. So the common cause, that NGO, is very famous for interfering in many important cases, including for the welfare of the pensioners. This common cause was founded by the father of Mr. Arun Shourie. We know very well Arun Shourie. He was a Minister of Communications and IT and also Minister of Disinvestment in Vajpayee government. He was also a famous journalist, and Arun Shourie's father, H.D. Shourie, he was an ICS officer. He retired. After retirement, he took up the common cause issue, and he founded the Common Cause organization and took up very many issues and fought in the Supreme Court against the government in order to force the government to follow certain principles in each and every matter, and accordingly this commutation of pension, we have to be thankful to Common Cause for their argument, for their taking up the issue in the Supreme Court, and they can win the case, and today we are enjoying the benefit of restoration of commuted pension after 15 years. This is because of the effort of Common Cause that we should not forget. Comrades, next is the commutation issue after 5th Central Pay Commission, after 6th Pay Commission, after 7th Pay Commission. What was the actual situation after these Pay Commission? After 5th Central Pay Commission, we know very well that the commutation was increased to 40%. Earlier it was 1/3 of the pension. After 5th Pay Commission, from 1196, it was 40% of the total pension that is allowed to us. So therefore, a 7% increase was allowed from 1196. Therefore, naturally, the question came, supposing the pensioner retired in between 1196 and the date of announcement and acceptance of the 5th Central Pay Commission recommendation, what will be the fate of those pensioners? The government said, you allow them. You allow, supposing they have received 1/3 pension, they can be allowed 7% and no need for any medical checkup also. Even though time has passed, you can give them 40% of, up to 40% of commuted pension, provided in the table that 7% has to be given according to their age factor. If they are aged 62, if they are aged 61, then the next birthday will be taken into account for determining the commutation value, commutation factor, and that factor should be applied, and the difference should be paid between that factor and also the earlier factor which was taken into account at the time of retirement. But those pensioners who died in between, supposing they have drawn the commutation and they have died, and in those cases the government has said that the families cannot receive the additional commutation pension because the pensioner has died, and the pensioner has to make an option of availing the 7% additional commutation of pension. Because the pensioner has died, the family cannot be given that additional pension. This is the 5th Central Pay Commission aftermath. Then let us come to 6th Pay Commission. When 6th Pay Commission recommendations came, the 40% did not undergo any change, but a revised commutation table was introduced, and it was introduced from 1/1/2006 itself. So therefore, people who retire after the implementation of 6th Pay Commission, there is no problem. They will take 40% commuted pension in the revised table, so therefore there is no problem. But the pensioners who retired in between 1/1/2006 and 2/9/2008, in between this period, if the pensioner has been there, what will be the fate? How that will be calculated? The government OM said that age at the original application can be taken into account, but here we can see the difference between 5th Central Pay Commission and 6th Pay Commission. 5th Central Pay Commission said that age should according to the table, the actual age of the pensioner and the next birthday should be taken into account. That is the 5th Pay Commission aftermath. But 6th Pay Commission said, after 6th Pay Commission, the government said in the OM that there is no need for any other age factor, but the age at the original application time, at the time of retirement, can be taken and it can be applied. But revised table implemented from 1/1/2006 has to be taken into account, and all the calculations will be based on the revised table only. This is the particular recommendation implemented by the government. And the question of persons who died, pensioners who died, in between 1/1/2006 and 2/9/2008, after receiving 40% in their old pay, what is their fate? Here the government said that the pay commission itself was very particular and it wanted an option to be given by the pensioner. There is no option, he died before the pay commission's recommendations were out. Therefore, the families cannot be paid the difference in amount between the increased pension based commuted value and the commuted value arrived at earlier. The families are not eligible because the pensioner did not make any option. This was the observation, this was the direction of the government of India after 6th pay commission. Then let us go to 7th pay commission. 7th pay commission was effected from 1/1/2016. But there is no change of commutation table, there is no change of any additional commutation of pension. So the 40% continues. The same table introduced from 1/1/2006 continues. Therefore, the government said that whatever the additional commutation of pension eligible to those pensioners who retired after 1/1/2016 and the date of release of the OM after the introduction of 7th pay commission pay scales, that difference can be paid to the families also without any objection because there is no change of commutation table, there is no change of commutation, quantum of commutation. Therefore, the government said that the difference can be paid and accordingly this position is available after each pay commission is before us. Now let us take up some important questions. The government has clarified some important questions. Number one, what would be the age to be used for commutation of additional commutable pension and which factor would be used for such additional commuted value of pension? These were the two clarifications sought after pay commissions naturally. The government has clarified after 5th pay commission. It said that 1/3 has become 40%. The additional commutation due for 1/3 portion will be based on the factor without any change, and the 7% additional commutation due will be on the next birthday of the table. This they have clarified. After 6th CPC, the age reckoned for calculation of commuted value of pension at the time of original application for commutation of pension will apply. The government has said that the age factor at the original application time will apply. But as a new table has been introduced after 1/1/2006, the 2/9/2008 OM has clearly introduced a new table. Therefore, that table has to be used for any additional commutation value being worked out and paid to the pensioners. And after 7th CPC, the additional commutation will be paid without any such different calculation because there is no change of commutation quantum and there is no change of any conditions like a new table etc. after 7th CPC. Then the second question is, from which date the reduction in pension on account of commutation will take effect? They clearly said that reduction in pension will take effect immediately after the payment of additional quantum of commuted pension. The date on which we receive, from that month onwards, the pension will be reduced and that will be continue for 15 years. What is the restoration time of additional pension? Because we know 15 years is the time of restoration for the original commutation. Suppose I additionally commute some percentage after the pay commission. What is the time of restoration of that portion? And the government said the date from which the additional commutation was paid, 15 years has to be calculated and that pension will be restored after 15 years from the date of payment of additional commutation of pension. There is one more question called a nomination. There is no Govt. We can make any relative eligible for receiving the commutation of pension. If there is a nomination, the nominated person will be paid the full amount of commuted pension if the pensioner dies without receiving the commutation value. Supposing there is no nomination, the pensioner dies before receiving the commuted value of pension, then it will be paid in the normal course to the spouse or to the children or to the parents, eligible parents, according to other considerations. They will be given. And if there is nobody to claim the commuted pension, there is no spouse, there is no parents, there is no children, then the legal heirs can claim the commuted value of pension, and that will be paid to the legal heirs. This is the present position, comrade. Then let us move on to the Parliament. Indian Parliament is the supreme body where the question of pension is decided. You know very well that the pension of the central government employees recruited after 1/1/2004 was sealed by the Parliament only. Both the ruling party and the main opposition party at that time, they have joined together and passed the bill of PFRDA in order to ensure a legal seal is given to the recovery that is being made at the rate of 10% of the pay and dearness allowance from each and every employee, and that is given to the pension fund manager, and they are not given any state funded pension as you go. This was made by the Parliament only. So we know the Parliament is very supreme. So a member of the Rajya Sabha from Punjab, he raised a question in the Parliament. The MP's name is Neeraj Dongi. He is a very famous person from Chandigarh. He raised the issue in the Parliament. He raised the question very recently on 22nd July of the current year, 22nd July 2021. He raised the question that the commutation of pension is restored after 15 years. But the rate of interest is calculated on FD basis. The FD interest has gone down. Only 5 to 6% of interest is given to FD also today. But you are taking an enhanced rate of interest for the commuted value of pension, and restoration is taken 15 long years. So why not you reduce the time of, is there any plan on the part of the government to reduce the time of restoration? This is the question. The government has replied in the negative. It has clearly said that the 6th Pay Commission and the 7th Pay Commission have made no recommendations on this issue. Therefore, the government is not considering reducing the period of commutation. It also said there was a court case in Delhi High Court. Delhi High Court has dismissed the case. That was on 17 January 2019. The Delhi High Court has dismissed the case without admitting it, and they have gone on appeal in the Supreme Court. And the Supreme Court also on 15th April 2019, they have also dismissed the SLP. Therefore, there is no condition that the commutation restoration time has to be reduced. So therefore, the government is not considering any reduction in the period of restoration. The 15 years will continue as per the table. This is the reply given by the government in the Parliament. And finally, we can come to the organizational position. What is the position of our organization? What we are going to do? We means the AIPRPA or the NCCPA. What is our position? We say that the commutation of pension taking 15 years for restoring the value is not justified, because the interest rate has gone down, so it has to be reduced. So we have also raised before the 7th Pay Commission. The 7th CPC did not agree, but we did not tire out. We will raise it. We are raising it. We will fight it. Our demand, we have gone to streets also. NCCP has organized program of action also. A very big dharna was also conducted in Delhi. We demand 10 years should be the restoration time. So it cannot be 15 years. It should be 10 years. There must be a struggle, and AIPRPA also endorsed the stand of NCCPA, and we will fight this issue and see that the restoration of commutation is not taken 15 long years, and we will ensure that the period is reduced in order to see that the pensioners are able to receive their commuted value at an earlier date itself. Thank you, comrades. I request all of you, please don't forget to subscribe by clicking the subscribe particular subscribe word and join our YouTube channel, and that way you will be receiving the immediate notification also whenever we upload a video on pension and family pension related issues. Thank you very much, comrade.